In the 1980s, the Minnesota legislature passed a law to crack down on the sale of cocaine. Under the law, a person who possessed 3 grams of crack cocaine was presumed to be a seller of drugs, but a person who possessed 3 grams of powder cocaine was not presumed to be a seller of drugs. The presumption kicked in at possession of 10 grams of powder cocaine. The result was that a person convicted of possession of 3 grams of crack cocaine served a longer sentence than another person convicted of possession of 9 grams, 3 times the amount of powder cocaine. But rather than basing those numbers on a solid study of street-level drug dealing, the legislature based the law on anecdotal evidence from a single county attorney based on his informal conversations with police officers. The law was challenged under the Equal Protection Guarantee in the Minnesota Constitution. A courageous trial judge, Judge Pamela Alexander, noted that the difference between the presumption for crack and powder cocaine had a clear and obvious racial dimension. African Americans were much more often charged and convicted of crack possession and thus served longer sentences, and whites were much more often charged and convicted of cocaine possession and distribution. Justice Rosalie Wall, writing for the Minnesota Supreme Court, determined the law was unconstitutional. Justice Wall wrote, "There comes a time when we cannot and must not close our eyes when presented with evidence that certain laws, regardless of the purpose for which they were enacted, discriminate unfairly on the basis of race. And under the Minnesota Constitution," she ruled, "such a law could not stand."